We have all parties present.
Okay, go ahead and call when you're ready.
Bottom of page 3, Judge. In cause number 2021 DCV 3174, Luis Elos Perez versus DARM Carriers DBA Quick Transport Solutions et al. Announcement of council, please.
Ashley Cedillo here on behalf of the plaintiff, Luis Perez. Good morning, Your Honor.
Good morning. Ms. Cedillo, do we have defense counsel at all?
No, Your Honor, both of the defendants have been properly served, but they have not answered. I do understand there's an issue with DBA Quick Transport. They're stating that they have no recollection in this case. We're trying to find out exactly what's going on because we may have to release them. But we were hoping Mr. Diwali, I apologize if I pronounced that, would submit an answer. He's been served. It took a while because he was on the road, but I know he has been served.
Right, and I'm showing a response was due back in November of 2021. Am I incorrect in that?
I believe that was for DBA Quick Transport Solution.
Okay,
It took a while to get Mr. Dewani served.
trying to see.
And I could be mistaken, Your Honor.
You're right. You're absolutely right. He didn't get served until February of this year, but we're already mid-July.
Yes, and we've been trying to push for him. He hasn't responded to anyone. We've shown the insurance carrier that he has been served, but they cannot until he tenders defense.
Okay,
Because there is coverage on this case.
all right. So let us go ahead and reset you so that you can figure out if the DBA is still going to stay in.
Okay.
And then you can also, we'll send a hearing, notice of the hearing to Mr. DeHalawa?
Your Honor, that's a better guess than not the way I cut it off.
I'm not sure, but let us go ahead and give him one more try. So I'm going to just set it for a status conference, but then at that point, you can talk with Judge Perez about going ahead and trying to get a default after that.
Yes, Your Honor.
Okay, but we gives them a little bit more time. And so let me double check. And we did put this, we put this on the record, right, Ms. Wright? Yes, okay. So I'm gonna go ahead and give you till mid-September
Yes, Your Honor.
to try and figure out the DBA situation. It'll give Mr. DeHalawal 60 more days. And then after that, you can talk to Judge Perez about trying to go ahead and just close it out with the default.
Yes, Your Honor.
All right. Okay, hopefully he responds. I mean, no one likes doing the default when they don't respond at all.
Especially when we know that there is confirmed coverage. Because we were discussing with them before.
Right.
Your Honor, that concludes all my business. May I please be excused?
Yes, nothing further. You may be excused.
Thank you, Your Honor. Have a good day.
Thank you. Right, Mr. Marufo, who's next?
Second on page 4, Judge.
Whenever you're ready.
In cause number 2022 DCV 0694, Rodolfo Covernali. Announcement council, please.
Good morning, Your Honor. This is Adam Milicincic on behalf of the petitioner, Mr. Covernali.
Yes, Your Honor. Troy Helling on behalf of Home Depot.
On behalf of the defense.
Home Depot, well, we were served with it because it relates to an incident that occurred at our store and that we might be interested in the 202 petition. And they're seeking deposition of one of our representatives.
Okay, all right. Okay, yeah, so you're an interested third party then, correct? You're not
That's
necessarily, you're not a defendant, you're an interested third party.
That's correct.
Now I understand. All right, so and just for the record, I'm showing that Robert Emmons is listed as the attorney for the plaintiff. Mr. Milicincic?
Yes, Your Honor. So Mr. Ammons I'm with the Ammons Law Firm, and I'm an attorney who works for Mr. Ammons.
Okay, that's what I needed to know. All right, so what is going on? And I know I'm not saying it correctly, your last name.
Yes, Your Honor, that's fine. Milicincic. So we're here today on the hearing that was noticed for our petition for a pre-suit deposition under Rule 202. And if I may share the screen, I have 5 or 6 slides here that may expedite what the little bit that I have to say.
Okay, go ahead.
Thank you. So as the court knows, of course, Rule 202 authorizes, with the court's permission, us to take pre-suit depositions for the purpose of investigating potential claims or suits. And there are certain circumstances like this one where it's prudent to do that because of the obligations that we have before filing suit under Rule 13 to make sure that we're naming the correct parties and bringing the proper claims. And so what we have requested is a short short deposition of a Home Depot representative on some very discrete and I believe relatively easy topics. And this relates to investigation of potential claims from an injury that occurred at a Home Depot store in El Paso in July of last year. And so the one item that we requested is somebody to talk about what the surveillance footage depicts of that incident, as well as to bring with them via subpoena ducis tecum copies of those videos. And from my conversations with Mr. Helling and his co-counsel, my understanding is that they've been told by someone that such footage has not been found. I don't dispute that that's what somebody told them, and we have attempted, and they have attempted to try to resolve these things without the need for a deposition. But what I did find, Your Honor, just yesterday, I happened to be in this part of El Paso and thought I would trust but verify. So I went to the aisle where this happened and looked, and lo and behold, there is a camera there. And this is just another angle of it. And the gentleman that you can see standing here at the bottom of the screen, that's about where Mr. Covernali was midway down aisle 6, where the closet rods are to hang up hangers and things like that. So we know there's a camera there. We know that we sent preservation demands to Home Depot very shortly after this incident via courier and fax to the actual store where this happened, as well as via mail to the National Corporate Legal Office. And so they were certainly on notice of this within a very short time after it happened. If in fact the videos don't exist, then we would like to get confirmation of that under oath by a Home Depot representative who's required under these procedures to do a thorough investigation of it. If the video exists, we want and need to see that before finalizing a decision or making a decision to file suit. And if the video was not preserved despite the timing of this demand, then that's also an important fact that needs to be confirmed under oath by somebody who's done a thorough investigation. And then second, Your Honor, equally as simple for purposes of getting the deposition, the deponent prepared, is we've asked them to identify the names of the people that placed the pipes on the shelf, the pipes that fell on Mr. Covernali. They've said that they probably can't pinpoint that individual, which I understand that makes a degree of sense. But the other thing that we've requested is to identify the people on the date of this incident who were responsible for the inspections and maintenance of the merchandise displays in that aisle, the aisle where the closet components are, and for that deponent to bring with him or her the records that would identify the employees that were on duty in those relevant roles on the date of this incident. And so this is, if it turns out that in spite of the camera being there, that in fact the footage was not preserved, then it's really this designated item number 2, where we expect to get meaningful and necessary information from the brief pre-suit deposition. And this will enable us to identify all potential and proper parties that need to be included in the case. And so in wrapping up, Your Honor, the balancing analysis that Rule 202.4 requires the court to make is to look at the benefits to us, the petitioner, of doing the deposition and weighing that against the burden or expense to Home Depot of presenting somebody for a deposition. And then, of course, subject to whatever protections, such as time limitations which we're fine with, and in fact suggest that the court finds necessary or appropriate. And so in summary, the benefit of doing this, as contrasted to the burden, is that it's going to be of great benefit to all potential parties in this case to see the incident happening before deciding how and whether to proceed, if in fact the video does exist as the camera suggests that it might. And again, if it doesn't, that's another important fact that may be part of an eventual lawsuit. And then as far as identifying the store employees that were responsible for this merchandise display, that's going to assist us in filing it in the correct jurisdiction, identifying all the potential parties at the outset before any case starts, rather than having to do that mid-suit by joining people in the middle of the case, which will cause extra time and expense. As I indicated, I'm very happy and in fact suggest that the deposition be time limited. It can certainly be completed within 90 minutes, probably much less than that, depending on the follow-up and the documents in response to the ducis tecum. And then one of the main things that we see in the case law, Your Honor, where the 202 depositions are denied, is that there can be a certain amount of unfairness when you're deposing an individual pre-suit and they don't have any notice of what it is that they're going to be asked about, because how are they going to prepare for that deposition? But in this instance, since we are requesting corporate representative testimony and have put the topics down in writing in advance, that potential burden to Home Depot doesn't exist, because they're getting a list of the topics before anybody ever has to testify. And so for those reasons, we believe the balancing analysis does favor this very short, simple, direct pre-suit deposition, and would ask the court to sign an order permitting us to do that. Thank you.
Right. Okay. Thank you for your presentation. I spent 21 years with the DA's office, so my gut is you're asking to see the evidence before trial. That's kind of my gut right now. So let me hear from Mr. Helling. I know he is not necessarily the defendant in this case, but he is possibly the defendant of the lawsuit that may occur. So Mr. Helling, go ahead and give me I did see your appearance in opposition that you filed on the 12th. I glanced over it, but if you'll just go ahead and for the record, summarize it to whatever serves you the best. So.
Sure. Thank you, Your Honor. And first off, I'm a little shocked that somebody goes into our store and conducts an investigation knowing that they're represented and not letting us know. But I'll just say at the outset that just because there's a dome in the middle of an aisle does not necessarily mean that there's a camera. As we've told counsel that we have not located any video of the incident. Otherwise, we arguably would have provided it to them, or would have presented somebody for deposition to clear it up. But I guess one of the most important things in this is they wish to investigate a claim to determine who are the proper parties to sue. They've clearly identified Home Depot as that company. All right. They now want to determine whether or not a store employee may have been involved in some form or fashion. And ultimately, we all know that if a store employee is involved, that the underlying individual or company that's going to be responsible would arguably be Home Depot. So whether they identify somebody as an individual, the person, their allegations are going to contain hey, they were within the scope of their employment, they were doing this and that. Home Depot, you're obviously responsible for any liability or damages in this case. So they've already identified the parties who they need to sue in this case, if they wish to do that. So bringing in a store employee, presumably for the purpose of defeating diversity jurisdiction, so the case can't be removed, I don't think it's proper, given the fact that you have a proper party already in Home Depot potentially. And so I mean, having a deposition to testify about identifying individuals that we will not be able to identify, who will ultimately full circle come around and Home Depot could be responsible for them. It just, to me, it's just a discovery mechanism that can be used during an underlying lawsuit if they filed one. And that goes true for anything with regard to discovering whether a video exists. I mean, that's discovery issues that can be addressed in the lawsuit itself. So I'm not sure that the potential claims or potential parties are unknown to plaintiff at this time, which is really the sole purpose of a 202 petition, not to conduct the discovery that otherwise is available to you once you file a lawsuit.
Okay, let me ask you two questions, and it's going to Mr. Helling. I'll let you speak again in a second, Mr. Malasinki, but let me ask Mr. Helling two questions. What about the situation that occurs in grocery stores where, for example, Frito-Lay comes and stocks their own merchandise, and Coca-Cola comes and stacks their own merchandise? What about that situation?
Correct, but that's not what he's seeking here. What he's seeking is information as to store employees. He's not even trying to get information as to third parties. He wants to depose. That's the issue. Yeah.
Okay. So can you quickly tell me what would the damage be to ask for 90 minutes of your rep time? Just go ahead and explain to me what would be your damage.
Well, I mean, the damage would be, I mean, the time and inconvenience and the fact that they get to take a couple of shots at deposing a corporate rep that on those issues. I mean, this is a pure discovery to identify store employees who were in the store at the time.
Yeah.
That's
Okay. All right, Mr. Melansink, and I see both points, obviously. I see both points. So let me ask you, why not just file the lawsuit against Home Depot and take it from there?
Well, that's what we actually don't know all the proper parties, Your Honor. Right? Certainly Home Depot is one of them, but what we are seeking to identify is individuals who, even when there's vicarious liability, still have individual claims that can be brought against them. And one of the reasons for doing it pre-suit is because if we file a case against them in federal court and then in their Rule 26 disclosures, they finally turn over these names that we're seeking, then that's just going to result in a non-suit and having to refile it or giving us the option and right to refile it in a state court. And so rather than going through all that and paying 2 filing fees and having them pay 2 answers and so forth, it's a lot cleaner and simpler to just get those names of those individuals on the front end. And as to the video, there's certainly, depending on what that shows, we may or may not bring a case. That's true in any instance where there's potential video footage of a car crash, of a incident in a store. The video could be great and encourage us to file a claim, or the video could turn out to be something that causes us not to pursue it. And so that's the reason for seeking this.
All right. I'm kind of a traditionalist, and so to me, the bite beforehand is not something I'm used to. I think the incident occurred on the property of Home Depot. I think they're going to be a party to the lawsuit. I think they'll answer immediately if there's a third-party vendor or stalker, and you'll know immediately because they'll be trying to get themselves off the case and letting another individual entity become responsible. So I'm going to go ahead and respectfully decline your motion at this point. All appeals, of course, are preserved for you, and so there is a record in case you need it. Mr. Helling, it's just because I'm a traditionalist. Start the process is kind of where I fall. All right.
Right.
So
thank you, Your Honor.
I wish you both the best of luck, and I hope you both can resolve this amicably.
Yes.
All right.
Thank you so much.
Thank you. Take care.